Yes, I do have that.
Before we can get to this, understand that.
Okay, just a minute.
Thank you. I'm on this.
This doesn't need to be on the record.
Oh, he doesn't want it on the record. Okay.
Understand that you're going to be on hold.
That is my understanding also.
Congratulations.
Thank you very much. We went out to Jimmy Kelly's and celebrated last night, so not too much. So I'm totally aware of we're arguing here. Well, I will share a secret. All the circuit court judges that were unopposed joined and did a shot. The unopposed circuit court judges got together at 12:15 and did shots of bourbon. And then I came back and did my impaired driving document.
Your Honor, we were supposed to be here today on our client's motion to dismiss. Yesterday, they filed an amended complaint. We were at Herb Fritch. Yesterday afternoon, the plaintiff filed an amended complaint. So I understand, that their rights do. We informed them that we were going to be hearing before the court to explain what's going on.
Right.
I don't know if I'm covered or not, but I haven't seen it this morning.
Would that be Mr. Russell? Is that Herbert? Is he Fritch? You're representing Fritch.
Yes, Your Honor.
And Your Honor, this is Mr. Gallagher representing Mr. Monroe. I'm here on the line.
Okay, very good. Can you hear us adequately?
Well enough, I suppose, as you came over the phone.
Okay. If you could get close to the microphone at the podium.
I'm never going to be quiet, so if you can't hear me, just try to speak up, and I'll try to talk louder. Again, Your Honor, supposed to have a hearing on a motion to dismiss. They filed an amended complaint yesterday. I want to seek the court's guidance on how to proceed here. I just want to make one point, and that's that, our original motion to dismiss, we made two primary arguments. Number one, the claim for time bar, and number two, that plaintiff had previously released all claims, including this very lawsuit, in a serious settlement agreement that indeed all conduct is based on. So, in response, and we also asked the court to make dismissal of the original complaint with prejudice. I understand that's somewhat unusual, but we argued in our initial motion paper there's nothing that he could do to say that time bar claims were unwind as multiple releases from liability and covenant not to sue in this very case. I just want to point out to the court, in response to that argument, that dismissal should be with prejudice, their response paper said the following. It was filed late. We pointed in our reply, but I'm not really going to argue too much about that. Here's what they said. They said, quote, plaintiff has not sought to amend this complaint, and there is no need to do so going forward. Ergo, the defendant's statement is inapplicable. They said that in a filing on either Tuesday night or Wednesday morning. We filed our reply Wednesday evening, and yesterday they moved. At the end of the day, they filed an amended complaint. So unfortunately, what they previously represented ended up not being the case. I think the prejudice of my client would be apparent. But again, I understand that that's the right to do under 15.01. I'm not going to quibble with that. I'm not going to quibble with that. I don't really know how the court wants to be here. I could argue the merits of our original motion, but that's probably moot. I'm somewhat prepared to argue whether a amended complaint still fails to state a claim, but I presume the court hasn't read it. So I think probably what we're going to need to do is refile.
Okay. I haven't read it because there's no response. I do have the amended complaint, so somehow that made it to me, but I don't have the other thing. So,
yeah, and Your Honor, if I may, just as a matter of, I think it would be an inefficient use of the court's time to get into the nuts and bolts and try and argue the case when there's a dispositive issue preliminarily with whether or not those, as they're labeled, settlement agreements would be enforceable. And we're happy to work with opposing counsel to set that specially. There's also, with respect to him and his client, there is sensitive information and material that they do not want part of the record. So we have no objection to them filing that under seal, or we can specially set that so that those matters don't become public. And if the court would prefer, we can schedule that accordingly, or we can brief the court on that, but whatever the court would prefer.
Okay, response, please.
Well, I do appreciate that sentiment. They've already made all of it.
Okay.
They've already violated the agreement, filed everything publicly in court, so I don't really think it's, well, I do appreciate that. I don't necessarily see the
if that helps you, and he's no objection, we can do that ASAP. Okay, draft your order, and I would suggest getting with the clerk to see what language they prefer. What I've done in conservatorships is, and I don't know that you would even have this issue here because I don't know anything about your case, is I even will change the names and switch them to Jane Doe's, John Doe's. I don't know if you need to go that far or not, or just put it under seal.
Understood, probably not.
Okay.
But I appreciate that. I think really the proof course is we'll follow the dismissal and complaint to due course. And
Okay.
get it heard as quickly as possible. Once you're on receipt of the filing,
Okay.
it will become clear why.
Right.
I understand it doesn't respond to late about ready yet.
Right.
Well, you understand why.
Okay.
There's some concern.
Okay, so we're continuing this then indefinitely, or?
You know, we can get into that. I think what I would like to do is follow up motion to dismiss their amended complaint.
Okay.
Once we we'll get that down quickly, and perhaps we could agree to a relatively quick schedule in a special setting.
Okay. Or check with Miss Wiley on any special setting. We're still trying to get caught up from
I
pandemic.
know that from earlier.
Yeah, a lot of our Friday afternoons, I think, are booked for, because that's my go-to day. Punish people for making me do things. It helps settle things, I swear.
And we're flexible here. We can accommodate the court schedule. We'll work around it.
Yeah, that's fine.
Okay.
We can work it out.
Okay.
If we need to do it on a regular day, that's fine.
That's fine. Okay.
If we do it on a deal like that, that'd be great.
Okay, very good. So do I need to do anything else today? I just said wait for you all to follow your order on the sealing of the case and your motion to come in. Okay.
Right.
Well, Mr. Harvey, you weren't here for a long time.
Well, Your Honor, I'm glad to be here. Can I talk to my co-counsel?
Yes, you may.
He's leaves, so I need his permission.
Oh, absolutely.
I'm being told that we're also probably going to need to follow up in state discovery. They served quite a lot of discovery with one of the.
Okay, yes. Since this is a dispositive motion coming down, let's put a stay on any discovery responses being due pending the court's decision on the dispositive issue.
Yes, Your Honor.
Thank you. Okay. Y'all have a good weekend.
Have a
Good
good
to see Mr. Harwell. And
Always good to see you.
thank you.
Thank you.
Thank you, sir. Have a good weekend. Okay. Well, that was short and sweet, wasn't it? You get a per diem for that. Okay. Oh, so where's that? Could be downtown. That sounds like domestic.
Excuse me, can I leave now? It's Frank Monroe.
Pardon?
This is Frank Monroe from the previous case with Mr. Fritch.
Yes.
Can I leave now?
Yes.
Is everything done?
Yes, sir. You can leave. My apologies for not saying that to you.
All right, thank you very much for your time, ma'am. Have a wonderful weekend.
You are excused.
Thank you.
All right. Thank you. You have a good weekend, too. Yes, ma'am. How can I help?
Thank you. Please be seated. This is a matter of motion to dismiss the amended complaint, Frank D. Monroe and Herb Fritch, 22C103. This is the defendant's motion, so if whoever's going to argue on behalf of the defendant, we go ahead, please.
Good morning, Your Honor. May it please the court, Jay Harbison, along with my colleagues, Ms. Marie Scott, Mr. Aubrey Harwell, on behalf of the defendant, Mr. Herb Fritch. I want to first start by saying that I appreciate the court accommodating my schedule this morning.
Absolutely.
My fourth motion in a row, starting at 8 a.m., so I think I know where I am, and we'll proceed from there. As the court noted, we're here on our motion to dismiss the amended complaint, and we ask that it be done so with prejudice, because with all due respect, there's no set of facts that are pled, or that could be pled, that could entitle the plaintiff to any relief here. I'll talk about each of our three grounds in a moment, but just to summarize those at the beginning, the complaint should be dismissed, the amended complaint should be dismissed for three independent reasons. And those are that the claims are time barred as a matter of law, that the plaintiff previously released the exact claims he's now trying to bring in this case, and then third, that the three stated counts of negligence per se do not state a claim. before I kind of turn to the substance, I want to talk briefly about some of the allegations in the amended complaint because I think those are pretty important. So the plaintiff alleges that he was married to a woman named Tiffany Monroe, who gave birth during their marriage to 2 children in 2010 and 2012, respectively. The plaintiff then goes on to allege, however, that our client, the defendant, is actually the biological father of these two children. Critically important, though, is that there's no allegation anywhere in the complaint or the affidavit attached to it that my client, the defendant, has ever been legally adjudicated to have any parental or guardianship rights over these children. I also think it's important to note that, respectfully, Your Honor, this is not a paternity action. I don't even believe this court has jurisdiction over those types of actions. This is a tort claim. They're seeking $6.3 million in damages in this case. So, several years after the birth of these children, the plaintiff alleges that he entered into a series of settlement agreements with my client. And those are dated 2016, 2019, and 2020. We attached those as Exhibits 1 to 3 to our motion. They're part of the record in this case. And I want to reiterate that consideration of those agreements under Rule 12.06 does not convert this into one for summary judgment because they're explicitly referenced in the complaint in paragraph 22. I don't think that the plaintiff disputes this, but I did just want to put that out there and put it on the record. And so at bottom, what happened under these agreements is this. My client agreed to pay substantial sums of money to the plaintiff in exchange for his promises not to bring this very case. The releases are in there multiple times, particularly the first settlement agreement dated 2016. And so our first argument for dismissal is that these claims are time-barred. The amended complaint makes multiple references to this being a tort action, and it then in paragraphs 22 to 24, I believe, makes 3 separate claims for negligence per se. So we would submit that the 1-year statute of limitations applies. I don't think that that's something that's disputed either. The bulk of the allegations concern events that happened years and years ago. There's even a reference to the decade of action allegations. And so really the gravamen of the amended complaint is that entering into these settlement agreements, again in 16, 19, and 20, allegedly caused the plaintiff some kind of harm. I want to point out a couple of specific allegations because I think those are important to this piece of our argument. And there's multiple references to conduct that occurred, quote, years ago. Paragraph 5 says it's a tort action that arises from events that occurred over the last decade. Paragraph 19 says that some of my clients' alleged outrageous conduct was having the plaintiff enter into these agreements in 16, 19, and 20. I think perhaps most important, though, is the plaintiff's own affidavit submitted along with the amended complaint. And that says that my client's alleged conduct has caused him, quote, years of mental stress and psychiatric damage. So he's been suffering for years by his own sworn testimony. All of that conduct is outside the 1-year statute of limitations. And all of this is important because it shows that the plaintiff knew of both his alleged injuries and their alleged cause years before, I think it would be January 18th of 2021, which would be 1 year before filing the case. And so under the discovery rule, the plaintiff admittedly knew everything well before the clock expired. And so in response to this argument that we've made about statute of limitations, the plaintiff claims that this doesn't matter because he was allegedly hospitalized on January the 26th of 2021, just within the limitations period. And so the plaintiff says, well, I was hospitalized within the limitations period, so therefore my claims are not time-barred. But, Your Honor, respectfully, it's clear from the 4 corners of the amended complaint and his affidavit that that alleged injury is just a continuation of the injuries he supposedly knew about years prior. There's no different conduct alleged. It's just, I think one way that I think about it is the way it's pled is it's a flare-up of stuff that happened outside the limitations period. And so we put this in our briefing. We cited several cases, specifically the Kenton and Wansley cases. And they said Tennessee does not recognize continuing torts. The discovery rule applies. So there's no allegation this hospitalization within the limitations period stems from any new conduct from my client. In fact, the plaintiff actually says the exact opposite. He says he was hospitalized as a direct result of defendant's actions and conduct that happened outside the limitations period. And so allegations that he suffered some kind of continuing injury or continuing emotional distress within 1 year filing doesn't change the fact that he admittedly knew of both his injuries and its cause years ago. And I want to highlight a quotation from the Wansley case, and I'll just read it for the court. It says, quote, "We hold that the continuous tort theory has been subsumed by the discovery rule. In a case in which a plaintiff learns of his injuries and learns of the causal connection to the defendant's conduct and continues to be subjected to such conduct, the discovery rule applies, and a plaintiff will be forever barred from bringing suit if he fails to bring suit within 1 year of the discovery of his injury and its cause." That is exactly what's happening here in this case, Your Honor. The discovery rule applies. His hospitalization doesn't save his case. He admittedly knew about all this years ago. So then, the plaintiff then kind of shifts again in response and seems to be arguing that this lawsuit is timely because some of the conduct alleged in the complaint occurred in February 2021. That's what their response brief says. It says, well, some of this happened in February 2021 within the limitations period. With all due respect, Your Honor, I've read the amended complaint and the affidavit at least a dozen times, probably more like 24 times. There's no reference to February 2021 in there. Now, paragraph 19 does say that my client asked the plaintiff to enter into another settlement agreement days after he was released from the hospital. But his affidavit attached to the amended complaint indicates that happened when he signed the third agreement, which was in January of 2020. So with all due respect, it doesn't, it's a little inconsistent there, and it doesn't really make sense to me. Perhaps Mr. Gallagher can explain. But what really matters with all of this is that there's no actionable conduct by my client pled within the limitations period. So even giving the plaintiff the benefit of the doubt, which of course I understand we have to do at this stage, drawing all inferences in his favor, all of that. So let's just assume for a moment that my client did approach the plaintiff in February 2021 and asked him to enter into another agreement. My question would be, what about that is actionable? What about that conduct, assuming it's true, is tortious? And what about that conduct could possibly give rise to any liability under the three stated claims for negligence per se? And I think the answers to those questions are that it's not actionable, it's not tortious, and it doesn't give rise to any liability for his three stated claims. On top of all of that, this supposed conduct in February of 2021, when you read what he says in paragraph 19, it's pretty clear to me that that's just a continuation of all the conduct that he's alleged took place over the past decade. So it kind of goes back into the argument I was making earlier about the continuing tort theory, which Tennessee does not recognize. That's yet another reason that this February 2021 argument that they're making doesn't have any legal merit. And so now I want to turn to the release argument that we've made. So the second independent reason for dismissal on top of the statute of limitations is that the plaintiff released these claims. First settlement agreement, 2016, has a broad release from liability. The plaintiff promised not to bring this exact case. And so to get out of this, the plaintiff makes two arguments.
I'm going to make an objection here, Your Honor. We're not alleging breach of contract. So all of these arguments are outside the scope of the complaint. Our complaint doesn't include any of the nuts and bolts of the substantive agreements within those contracts.
And Your
Our
Honor,
whole position is they are not enforceable. So these are all well pled in an answer or affirmative defenses, but not in a 12B motion to dismiss.
well, that's literally what I was just about to talk about, so this timing was good there. We've argued that this case should be dismissed under Rule 12 because of the promises that the plaintiff made in these agreements. He said, I'm not going to sue you. And then he turned around and sued us. And so in order to be able to do that, the plaintiff has to unwind the agreements. And so the way he's trying to do that is two ways. He's trying to say that he executed them under some form of duress, and then he's trying to say that they're entirely unenforceable, as a matter of public policy. And so I want to talk about duress first, because that's the only way he gets out of the releases, right, is if he can somehow invalidate these agreements.
Objection, that's not our argument, Your Honor. Duress is not the reason these are unenforceable. These agreements are void of initiative. You cannot agree to make collusion. You cannot agree to violate the statute. These contracts are one. You cannot agree to break the law. That is our position, not duress, Your Honor.
Well, if he's going to say that they're not pursuing on a theory of duress.
One at a time, please. First, and then you follow.
If they're not, with all due respect, I couldn't make too much clarity out of what they're saying with duress. The complaint references duress multiple times, so I was drawing inferences in their favor and trying to think that they were probably trying to get out of the agreements by saying
So
duress.
instead, you're not saying duress then. The plaintiff is not asserting duress.
We're not asserting duress, rather, we're saying these agreements in and of themselves are wholly unenforceable. You cannot agree to break the law.
How is the law being broken?
Your Honor, under the agreement to agree to commit collusion, a third non-party to divorce is paying someone to not consent to their own divorce. These are unenforceable. These upstairs to Judge Smith. We would not allow these agreements. They're not allowed under the adoption statute. You can't agree for someone to not exercise parental rights with their children who are legally theirs. These are unenforceable. And we cited that in our memorandum.
How much money has exchanged hands over the 3 agreements?
Well, Your Honor, let's talk. We have to look at the. We have to look. I understand. I think we're about to get an argument that's outside the 4 corners of the complaint.
Sure.
So, judging by the 4 corners of the complaint, my client agreed to pay, I think, several $100,000. I think it's about $400. I think that's all we can do at this point. So let's talk about public policy then, because that's obviously where Mr. Gallagher wants to go. They say in their papers that the agreements violate public policy because it's supposedly a crime for someone to, and I'm quoting their brief here. This is on page 4 of their response brief. Quote, to pay money in exchange for a parent or guardian agreeing to surrender or terminate their parental rights. The authority that the plaintiff cites for this proposition is TCA 36-1-109B and the Stutz case, STUTZ. Respectfully, both that statute and that case deal with adoption. In this case, before the court this morning, does not deal with adoption at all. But let's give them the benefit of the doubt, and let's say, even if this statute applies, with all due respect, the plaintiff is not correct in what it actually prohibits. The way that they say that it's a crime to pay money in exchange for a parent or guardian agreeing to surrender or terminate their parental rights. But look at the statute itself. What it actually prohibits is the sale of parental or guardianship rights by someone who already has those rights. Which to me is kind of further proof that it applies only to adoptions. But again, I touched on this in the beginning, and I said it was important, and here's why. There's no allegation that my client ever had any parental or guardianship rights to sell. As pled in the complaint, the plaintiff, and not my client, is the presumptive father of these children because they were born during his marriage to Miss Monroe. Despite the allegations that my client is the biological father, again, there's no allegation that he has ever been declared or adjudicated their legal parent or guardian. So he had no rights to sell under that statute that they're talking about. On page 20 of our brief, we cited a case called In re Bernard T, which provides some clarity to me on this issue. And it says, quote, being a child's biological father is not sufficient by itself to qualify a man as a child's legal parent. In re Bernard T also goes on to talk about ways in which parentage can be established, but that's not what we're talking about here. Again, this is not a paternity case. They're seeking money damages from my client. Another piece to all of this, Your Honor, and this is briefed probably too exhaustively, and that's my fault, in our papers, is that the severability clause saves any release provisions. Because here, I want to center us back to where I am in my argument. We're talking about our second ground for dismissal, which is that the plaintiff released these claims. So even if portions of the agreements are legally unenforceable, the law says that the severability clause would save the release provisions. We cited some authority in our papers. It's on pages 16 and 17. It's the Baugh case, B-A-U-G-H, and a case called In re Baby. They say that when portions of an agreement are legally severable, the court is supposed to give effect to the portions that are enforceable and validate only those portions that are unenforceable. I would also like to draw the court's attention to that what their papers say and what Mr. Gallagher is saying this morning, arguing that these agreements are unenforceable, those provisions about the divorce, about parental rights and things like that are only in the second and third agreement. Look at the first agreement itself. It's the longer one. The first agreement is the one that has the release provisions in it. The second and third agreements are very short, and they incorporate and point back to the first one. They're just kind of tag-along agreements. Everything they're saying is unenforceable about these agreements. Let's just assume it is for a moment. That's only in the second and third agreement. There's nothing in the first agreement that they point to that's unenforceable, and that's where the release provision is. So even if there is parts of it that are unenforceable, we submit that the severability clause would save the rest, including the release provisions. And that kind of dovetails with my last argument about the releases, which they didn't address in their response, and that's what I call the tender back. Page 17 of our brief, we cited a case called Dobbins, which was written by then Judge Kirby before she took the Tennessee Supreme Court. And that says, quote, requiring the return of any consideration paid is a widely recognized condition precedent for a party seeking to avoid a settlement agreement, which is what they're trying to do here. They're trying to avoid these agreements to get out of the releases. There's no allegation whatsoever that the plaintiff ever tendered back or tried to tender back the substantial settlement proceeds under these contracts. And so that serves as yet another reason the plaintiff can't unwind these settlement agreements as a matter of law. I know I've been going on for a moment and I'm getting fairly close to being done. I want to talk now about the three stated claims of negligence per se, a third independent reason for dismissal. The amended complaint on page 5, I think it's actually footnote 5, says that violations of a statute establishes a standard of care and constitutes negligence per se. With all due respect, Your Honor, and I think the court probably knows this well, that's not what the law says. The Raines case that we cited in our brief, written by then Judge Koch before he took the bench of the Tennessee Supreme Court, makes it clear that not every statutory violation creates a cause of action for negligence per se. There's a multi-part test, this is in our papers, that courts look to see whether alleged violations of a criminal statute creates a civil cause of action for negligence per se. And respectfully, none of the plaintiff's three claims for negligence per se, paragraphs 22 to 24, meet that test. And so let's take each of those in turn. Paragraph 22 says negligence per se, and it attempts to assert a claim of negligence per se for violation of that statute we were talking about earlier, the adoption statute, TCA 36-109B. I won't repeat myself here, Your Honor, but again, that statute does not prohibit what the plaintiff claims it prohibits, nor is there any allegation that my client could have possibly violated it, because he had no such rights to sell. Also, there's no private right of action under that statute. I did an exhaustive search. I couldn't find anything in Tennessee or any related jurisdiction that created a claim of negligence per se for violating any type of adoption or even other type of custody or parental rights statute. I don't think that violation of this statute, even if my client violated it, which it's not alleged that he did, would give rise to this cause of action for negligence per se. Moving on to paragraph 23, another stated claim of negligence per se. It says, my client violated some unknown and unidentified statute and is somehow defrauding the state of Texas child support services by allowing these two children to receive Medicaid coverage. With all due respect, I don't think the plaintiff has any standing to bring this claim, even if it's true, which I understand we have to do at this point. The plaintiff can't sue my client for allegedly committing some type of health care fraud in Texas. I don't have it in my outline, but we did cite a case in our brief that it's a federal case, and I'm blanking on the name, I apologize, that talks about how there is no private right of action for committing any type of health care fraud. So I don't see how the plaintiff has standing to bring that claim against my client. I also, with all due respect, don't understand how that could cause the plaintiff any damages. He says, you defrauded the state of Texas and that damaged me, but we have to have causation here, right? How, first of all, and what damage. And so paragraph 23, I will submit that claim fails for lack of standing, lack of causation, and lack of any actual damages. Finally, paragraph 24, which is similar. It alleges my client violated another unknown and unidentified statute by, quote, fraudulently making the plaintiff's own child support payments for him. Again, like the paragraph above, I'm not aware of any statute that could possibly apply here. I've looked, couldn't find one, so it's not clear to me at all how this is a claim of negligence per se. With all due respect, there's no basis, nor is the plaintiff cited to any legal basis to impose a standard of conduct on my client for allegedly paying the plaintiff's bills for him. It's also respectfully not clear how that could cause any type of injury. If somebody pays your bills for you, how does that hurt you? So paragraph 24, we would submit fails for a lack of duty, a lack of causation, and a lack of damages. Finally, Your Honor, if the court is inclined to grant our motion to dismiss the amended complaint and does so with prejudice, we would request an award of attorney's fees under both the attorney's fee provision of the first settlement agreement, the one from 2016, as well as TCA 2012-119C. We also put this in our papers. In the plaintiff's response, they made a request for their attorney's fees. Respectfully, I'm unaware of any basis, legal basis under which the court has the authority to do so. And if the court would like, the citation for the healthcare case we was talking about is called Anderson, and it's on page 20 of our brief. That case dismissed a Medicare fraud claim for lack of standing because it said, quote, no private cause of action exists under the federal healthcare statute.
Okay, that's like that was in the brief.
It's in the brief, yes, Your Honor.
Thank you.
That's all I have. Thank you, Your Honor.
Response, please.
Good morning, Your Honor.
Good morning.
And thank you again for accommodating our schedule. We're very sorry it took us time. So with respect to the defendant's motion, we want to highlight a few points. And we understand the court's well briefed, so we want to be considerate of the court's time. First and foremost, this action is not time barred. Our client was hospitalized, and the damages and the compensatory damages he's seeking are from January 26, 2021. Our complaint was filed January 18, 2022, well within the statute of limitations. Now, moving on to the point of enforceability, that would be the dispositive issue in this case. We have not alleged breach of contract as a cause of action. However, if this court is inclined to enforce those agreements, we will gladly request leave to amend our complaint to include in the alternative of breach of contract. Now, the court specifically asked how much money has changed hands. I can't answer that question accurately. As of today, and I can ask my client, I think to the tune of $400,000 is the amount ballpark. But under the same agreements, as of today, the defendant is $110,000 in arrears. She's not made any payments since May 2020. To the best of my knowledge, my client confirmed this here this morning. Our position, Your Honor, is that none of the agreements are enforceable for several reasons. Number one, there is collusion committed here. You're having a party agree not to contest his own divorce in exchange for payment. And every divorce complaint, you're required to submit, along with your petition, a signed affidavit by the petitioner saying this action is not brought out of levity, it is not brought out of collusion, and it is brought out of sincerity and truth therein. That's not the case, and I'm sure they didn't disclose that fact when the defendant handled the plaintiff's divorce. That is the basis and the impetus of our complaint. The outrageous conduct alleged here is that the defendant knew our client's history. The defendant knew that our client came up through foster care, that he has been abused in the past. He is intimately aware and familiar with his family, and that he had these children out of his wedlock. If the defendant wants to claim paternity, and I agree with their position. This is not a paternity action. However, Tennessee is the best interest of the child state. If the defendant wants to acknowledge paternity, we can gladly take judicial notice of that fact. And we're not arguing that Texas, as far as the most recent arguments made by the defendant, plaintiff never gave him the right to make child support payments on his behalf. Texas, unlike Tennessee, is not an income shares model. It bases child support solely on the income of the father. Right now, my client's child support monthly obligation is $600. That would not be the case if we were basing that statutorily off of the defendant's income. We do want to point out that this action is not time barred. There's nothing preventing this to do. It's brought well within the statute of limitations, and that the contract works both ways. So if the court's willing to overlook the collusion, that it violates the statute, and with all due respect, that statute is not open to interpretation. It is not restrictive of adoptions. It is buying and selling purchasing parental rights. That's what we're talking about here. Paying someone not to exercise parental visitation rights of the child. How is that in any way in the best interest of the children or legal? Under the statute, it's perfectly cited in our complaint that that's negligence per se. You can't agree. Contracts 101, you cannot agree to break the law. It's unenforceable, and that is our position. That's why those agreements should be set aside and not enforced by this court. If they are, if the court does take a position, we want to allow these agreements to be enforceable. Even if they want to sever any of the clauses therein, you allow the defendant to leave court today. What clauses remain? Those are the substance of the agreements. So what then? You're just time barred and we cannot honor the other parts of the agreement? We're not going to, you can't have it both ways. The defendant can't say, we're going to enforce the agreement. You cannot bring claims against us. Oh, and by the way, we're not going to make payments under the agreement. And also, Your Honor, in the response, in the motion to dismiss, the defendant does bring up facts that are outside of the complaint. We do reference in our complaint the agreements and we acknowledge them. However, the genesis of our complaint and the impetus of our complaint is trying to coerce our client in entering these agreements, which are void ab initio. They are against the law. They are collusion and they're unenforceable. Lastly, if the court has any reservations, we'll gladly file supplemental briefs. We want the court to take those under advisement. We want the court to be well informed. We have nothing to hide. The defendant has an impeccable legal team to recognize that. They're good attorneys, but there's no positive way to spend it. Our client may proceed with it. Our position is he should be allowed to pursue this personal injury claim. And then the alternative, if the court is inclined to enforce those agreements, then we do request leave to amend our complaint, allow us to insert those breach of contract claims. Thank you, Your Honor.
Just a few quick points, Your Honor, about the time limit. I didn't hear anything about the in response to the continuing tort theory, which is not recognized. We rest on that. As far as the $110,000 that was just referenced, with all due respect, that's not in the complaint anywhere. I don't think that should be coming in at this stage. I don't see not a court order in the complaint. That's what we have to be done by. Talking about agreeing not to contest a divorce. Respectfully, what's their legal basis for that? I haven't seen any authority cited. They've had 2 opportunities to do that at this point. Still haven't seen any. Talking about making the agreements void ab initio, again, I would just like to reemphasize the first settlement agreement, the one with the release provisions in it in 2016, doesn't have any of these things in it that they're claiming are unenforceable. First settlement agreement just says disputes arisen between the parties. The plaintiff has threatened the defendant with litigation. We wish to resolve these. Here's how we're going to do it. Here's confidentiality. Here's non-disparagement. Here's severability. Here's integration. All the kind of standard things you would see in a fairly robust settlement agreement. None of these things that they're claiming are unenforceable are in that first agreement from 2016. Unless the court has any questions, I think that's all I have.
I do not.
Thank you, Your Honor.
Do you all have anything else? As I said earlier, I'm going to take this under advisement. It is a